Welcome back to the Legal Smith Unleashed. I am attorney Kurt Smith here today with my legal monkey Dylan Smith, paralegal extraordinaire, all things court related. Hey, Dill.
Hey, how's it going?
It's going pretty well. How are you?
Oh, not too bad. Just had a stellar day down at the courthouse.
Oh, they seem to be all stellar days down at the courthouse these days.
They sure do.
We've had 6 trials over the past 9 days.
Yeah, it's been a lot.
I think we get a little respite tomorrow. So 6 out of 10. That's all different trials.
All different cases.
So that's it's a lot.
Yeah.
But boy, victory after victory after victory.
I never really get tired of it.
Understood. But we did have an interesting case today that wasn't trial related.
Yeah.
And as the story goes, I took a consult, it's recently, right, with a client or a prospective client who apparently got a divorce. Now, he and the wife at the time divorced each other by themselves. They did their own divorce decree, and in that divorce decree, essentially, is a very short-term marriage, about 5 years, no kids. These are all the hallmarks of let's just be done and the split and go our separate ways. But the husband makes quite a bit of money. Not Donald Trump money, but money nonetheless, right? And the wife is not so fortunate, and she's got MS, but she came into the marriage with MS, and she came into the marriage kind of, the waitress of the two, and he's the powerful, banking magnate, that has more money than she does, and they decide to get a divorce. Did it themselves, and essentially what happened is they split their asset account, and he took all the debts and shipped her back home where she came from. So
sounds like he was pretty generous in that.
Very generous, because apparently she was a spender, right? She loved her Amazon Prime, and she loved her whatever else you can buy online. I don't know. You're more up on that stuff than I am.
I don't know what women like to shop for online too much. No, I don't know. Who knows?
So in any event, they did this divorce, and the husband calls and he says, "Hey, Mr. Smith, you've got to protect me," right? Because the wife wants to throw out the entire divorce and start over. And I don't want to do that. I already gave her half the money, and I already took on 100% of the debt. What more am I supposed to do? And I said, "You know what, sir? You are my kind of guy. I will take your case, and we'll see what we can do to win." So we take the case, and they had filed what is called a motion to set aside the decree, which essentially says, I know we're divorced today, and I know we made this agreement that we are divorced and we should be divorced forever, but I would like to undo that agreement, throw the entire agreement out, and start over.
Wow.
So that was their motion, and we filed an opposition saying that is an adorable prospect, but here's what you really got to think about. Number one, you guys did this yourself. Number two, you agreed on what it is you're going to do. You formed a contractual relationship. Number three, you went in and definitively defined what the assets and debts were, and he gave you your share of the assets, and he took on 100% of the debt. What is it you're looking for? So there's that. And number four, you really don't qualify for this, because what you're trying to do is set this aside on some kind of a ground of fraud or mistake or something of that nature, and you've got no fraud, you've got no mistake, you've got no nothing that would satisfy the statute to set this aside. So, Judge, please go ahead and deny that motion, and really that should be about the end of it. They've got an opportunity to reply, but instead of a reply, I got a phone call. I got a phone call from opposing counsel that said, "Hey, Mr. Smith, how are you?" It turns out my client says that she consulted with you in the past, and as a result, you have formed an attorney-client relationship, and as such, you cannot be the attorney on this case.
Wow.
Well, that's news to me.
Must have been a shocking phone call.
It was quite the slap in the face. But it's not the first time I've ever had that phone call, and it probably won't be the last. But I happen to be sitting in front of. There's this thing that they have now. It's kind of like got a square TV-looking screen,
Okay.
and there's this flat surface board in front of me, and it's got all kinds of letters on it, and it's called a computer.
Huh.
Right? Yeah, it's a new thing. They're really catching on. I think they're really going to take this.
Seems like just a fad. I don't know.
Take the city by storm once it catches on. So I hop on my computer and I go into my client relationship tool and I look up this lady's name and I said, I'm looking and I don't see her. Usually when people call in, we put their names in here as somebody who would have called in, Miss Attorney, I don't see her. And the attorney's like, well, it's true. And I go, well, hang on, let me check my notes here. And I look and I say, well, okay, I don't see that. And usually I take detailed notes for these consultations. I don't see any notes. Are you sure it was me? Oh, we're sure. I'm like, well, let me just say, when did you say this took place? Oh, it took place on X date. And I go back and I look at my calendar and I said, that's really strange because I'm listed as being in a whole nother meeting with a whole nother person at that time. I really don't think this is me. And she says, well, too bad. It's you. And I need you to get off the case. And I said, well, that is an adorable suggestion. I appreciate that. But the answer is no. And there is, so you're going to make me file a motion? I said, I guess you're going to do what you got to do. Now, this takes me back because this attorney, she's a little young. She's kind of new to the attorney practice.
Okay.
And back in the day, back in old Vegas, let's just say, if there was a high-profile person being divorced, the trick in that would be that they would go back and they would get the guy that they want, and then they'd get consults with the 6 or 8 other guys that they didn't want, and they'd take a consult with them and go, okay, you're conflicted, and you're conflicted, and you're conflicted, and you're conflicted, and all we got left is Joe Schmo over here. Good luck with him, right?
Yeah.
And that used to be a very common practice. And in fact, we have here in Nevada, and probably in every state, what's called here in Nevada, the Nevada Rules of Professional Conduct. And the rules used to say, look, if you have any contact with somebody, that is going to establish an attorney-client relationship, and you're out. And so it was kind of a dirty trick on the part of the casino magnate or business person, billionaire in town that was looking to get a divorce because they could conflict out all the other good counsels.
It's like, reminds me of when I was in 3rd grade. I called dibs on all the pretty girls in the class as my girlfriend, and you're all out of luck.
But that worked for you. I'm not sure how that worked for you, but it's not working for them. So there's this rule that says that they changed the rules eventually. And what the new rules said, or they're still old at this point, but what the rules eventually started to say was, look, we're starting to see a lot more attorneys that are not staying at one firm. And not only attorneys, but secretaries and paralegals and all because we're seeing them go too. And the old rule said, hey, even if your paralegal goes over to the other firm, you're out.
Wow.
And so that would be a good trick too. We'll go send Julie over to the other firm, and she kind of like the Prestige, right? So we send Julie over, and Julie would then conflict the entire firm out. And so then they started talking about, well, you know what? If that happens, what you can do is you can build a Chinese wall, okay, like the Great Wall of China, right?
Sounds okay. It's positive. Okay,
Yeah,
it's not racist. Not
no,
racist.
because
Okay.
there was this thing called the Great Wall of China. So you guys can build a Chinese wall, and you can screen out the conflicted person, whether that be an attorney or a receptionist or a paralegal or whoever. And so that was the state of the law for a while. But then the law, even more recently, probably 2013-ish or so, has changed. And now the court is saying, the Nevada Supreme Court is saying, look, there's so much of this going on. There's so much movement. There's so much opportunity to say, you're out. People have a constitutional right to choose the attorney that they want to represent them.
Right.
And so no longer are we going to say, well, you say there's a conflict, so there must be a conflict. What happens, for example, if I go out to a dinner party and I start talking legal with people, and somebody comes up and goes, hey, by the way, I've got this hypothetical question, a friend of mine, and the friend turns out to be them, and the wife ends up calling and saying, hey, by the way, I want you to represent me in my divorce, and the other guy's like, well, we were at that dinner party and you gave me legal advice. And the reality is the court's saying, look, we're not doing that anymore, okay? What we're going to do now is, if there was a potential encounter, what you have to show is that, number one, you gave confidential information, and number two, there was a reasonable expectation of establishing an attorney-client relationship. And at the cocktail dinner party, that just simply wasn't the case. There's no legal services being offered. This guy was telling a story, and you asked for, what about this hypothetical thing? And we're not going to count that anymore. In fact, we're going to have a weighing test, okay? The prejudice to you versus the prejudice to the guy that wants this person as their legal counsel. So there we go. Okay, that's the state of the law today. Fast forward to today. Today we've got a hearing on this motion to conflict, right? And I walk into the courtroom, and there we are in front of one of our illustrious judges, and the attorney stands up and she's like, this isn't right. Mr. Smith's a liar, and he's a cheat, and he's a low down, dirty, disgraceful guy, and I want him off the case, and he's got to be off because there was this communication. And I looked at the judge and I said, look, Judge, here's the deal, okay? I've been coming in front of this court for 3 decades, okay? And throughout those decades, I have represented myself as an officer of the court, and I have conducted myself with integrity, and I will stand here as an officer of the court today and say, I have no independent recollection of ever having any meeting with this lady, okay? And even if I had, she would have had to disclose some kind of confidential information, which in our field, okay, in a family law field, is very difficult to do. Because when we talk about family law, you've got 2 parties, and there's this form. What's the form called you've got to fill out?
I'm sorry. To get a divorce?
Yeah.
A complaint for divorce?
Complaint for divorce, but then there's a financial form, right?
Oh, a financial disclosure form.
Financial disclosure form. And on that form, you've got to list all of your finances, right?
Yeah.
You've got to list bank accounts. You've got to list credit cards. You've got to list property. You've got to list cars. You've got to list retirement accounts, investments. Everything's got to be listed on there. And you sign that under penalty of perjury, saying, this is everything I have. Now, if in the course of this representation, you come up and the other side says, oh, well, wait a minute, you didn't list this, and you didn't list this, and you didn't list this, then what a lot of the courts will do is say, oh, you didn't want to list that? I'm giving that to the other side. Okay, so nobody wants to get caught with those pants down,
Yeah.
right? And so there's always a a danger that if you're going to be that way, you're going to lose. You're going to lose your property. So everybody's fairly honest about what they're doing and what the accounts are, and maybe the values are a little off here and there, but they've got to disclose that, and people are pretty good about doing that. Okay, so we disclose these finances, and then there's these mandatory rules showing, 16.2, which says you've got to now disclose all the proof of what these accounts actually are. And so we get into a situation now in a post-divorce where both parties worked together and listed out all their accounts and said, this is what they're worth, and I'm going to give this guy, all the debt, and I'm going to take half the assets. What is there confidential to be disclosed?
Nothing.
There's nothing. And so in our line of work, it's almost an irrelevant rule, because you can't point to anything confidential. You're not sitting there saying, oh, and by the way, I've got an account that I've got in the Cayman Islands. Please don't tell anyone. It's worth $5 million. And if he finds out, he's going to want my $5 million. We don't have that in most of these cases, and certainly not in this one where the parties were married a short while, blah, 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 right?
Yeah.
So that's the argument I make to the judge. And the judge looks at the opposing counsel and says, look, lady, what are you doing? I've known Mr. Smith for a long time. He's come in front of me countless times, right? And in fact, he runs a very high volume practice, and he has lots of clients. In fact, I know for a fact he turns clients away all the time. People that want to come in and pay him money, he's turning them away. Why would he take the time to choose this one guy who he doesn't know, he's never met, and say, I'm going to choose this guy to be the guy, right? I'm going to go out on a limb for this particular guy. It doesn't make any sense at all. And the attorney's like, well, that's not fair. You can't use that. This is like David and Goliath. You're letting Goliath come in here and pick on me, poor David, because, you don't know me as well. I'm new. I'm the new kid. And now you're picking on me? How dare you? Mr. Smith needs to be out of here because he's a big fat liar. And the judge is like, well, that was... Simmer down there, little lady. Those are harsh words in this courtroom, right? I mean, you better have something to back it up, and you don't. And in fact, what I was able to explain to the judge is, look, let's assume that a conversation took place. It certainly wasn't with me, but I did used to have a guy that worked here. Maybe it was him. But I don't have any notes, and he's not here anymore. Maybe it was him. So if we're going to build this Chinese wall, it's already built because the guy's no longer here, right? And the judge is like, oh, that sounds reasonable to me, right? Ma'am, what do you have to say? No, we can't do it. There's got to be this wall. And not only that, I want you to kick Mr. Smith off this case, but I also want you to throw out his opposition. So let's assume that they filed this motion to set aside. If they throw out my opposition, what does that do?
That means that their motion is unopposed. And
it's unopposed and it gets granted, yeah. Right? And she says, and if that's true, then the parties are still married, and my client needs alimony, okay? She's going to need a whole chunk of money to get her through this divorce. And the judge is like, wait, what? And not only that, I need a whole bunch of attorney fees because she's going to need to pay me for a lot longer. And the judge is like, is that right? That sounds like a really fascinating discussion. Certainly what you're not saying, young lady, certainly what you're not saying is that these parties who have now been divorced 4, 5, 6 months, who may have moved on, you don't want to undo the divorce and remarry them, do you? That's certainly, nobody in their right mind would ask for that. Is that what you're asking for? But yes! Oh, certainly you can't be serious. That's certainly nothing this court would ever entertain, right? And now you want all these other things. Well, listen, we'll have to discuss this at a later time. I can't do it right now. But perhaps what you would want to do, rather than give everybody a chance to get their wits about them, maybe if anybody wants to ask questions, I'll set up some time. You put some testimony on the record right now. And I said, oh, well, I'll ask some questions, Judge. I love asking questions. So the judge swears the lady in, and I start asking her questions. Listen, have we ever spoken before the time that you say we spoke on the phone? No. And do you know who this guy is? No. You ever spoken to this person on the phone? No. Was the call between you and the attorney you spoke to a video or phone? It was phone. Okay, and did you ever speak to this guy? Did you ever speak to this guy? Did you ever speak to this guy? These are all associates of my firm, by the way. Would you be able to tell their voice apart from my voice? Well, I don't know. Okay, so you don't know. You don't know anything, right? And can you explain to us what confidential information that you gave? Your Honor, that's not fair. There's all this confidential information. I said, Judge, listen, the whole concept here is that there was this confidential information shared. Right? But they are the one that filed the motion. They set forth the facts of the case. The facts are what the facts are. Now it's all out there. And I filed my opposition, and the opposition dealt with their facts. Where was the piece in there that says, hey, he couldn't have known this but for learning it from me confidentially? What piece of that is in there? Oh, it's an unfair question, Judge. And the judge's like, I don't think it's unfair at all. But I go, Judge, that's it for now. We'll do the rest. And so we're going to meet with that judge later and really deal with this. But the judge is like, look, we'll come back at another time. But when we do, we'll deal with this issue right up front. But let's assume, for the sake of argument, that I'm not going to disqualify Mr. Smith. Let's just say that, okay? I want you to be also prepared. Tell me all about the accounts that you say that he didn't disclose, and what are they and how much is in there. Let's just really be prepared to get to the meat of it. Well, how can I prepare that if Mr. Smith's going to be there? Well, assuming he doesn't get stricken from the case, which I'm not leaning towards right now. He's got this bald head that he likes to rub. Oh, yeah, I don't see the case, but be prepared, right? And Mr. Smith, you'd be prepared too, just in case. But then also be prepared to talk about this other stuff. I sure will, Judge. That sounds like a great way to go. And so, look, the reality is the rules have changed. And the funny part about this case, and what a lot of people don't always understand, is we cite case law in these briefs to show the judge. This is why I'm right, and the Nevada Supreme Court agrees with me. Here's what they said. All of her cases were like 1985 and before. She skipped all of the newer cases that totally don't support her case. And the judge isn't a moron, right? Yeah. This judge has been on the bench for decades, right? And it's like, you've got to show me more than you've given me. You haven't showed it to me, and even if you did, there's nothing disqualifying here. I just don't see it. So. And you just make yourself look really foolish, right?
Yeah.
And notwithstanding the fact that you think you have this great argument, why would you make an argument that is only going to delay the case, that is only going to cost your money, who you say has your client who has no money? Why would you force them now into this secondary evidentiary hearing where they have no chance of winning? It doesn't make any sense, right? And the judge is like, you do realize that there's, like, you say your client's poor, but you're the one forcing the issue. Poor old Mr. Smith over here. He's just an innocent bystander. So we get done with the case, and I look over at counsel, and I said, well, listen, it was very nice to meet you. And she's like, what? We've met before. I'm like, I don't remember. I think I would have remembered somebody like you. But it was kind of a fun little thing. So that's one of the fun little things we've done over the past few days that really stand out.
Such a slap in the face.
Why do you think it's a slap in the face?
Well, there's a lot of reasons why I think you would want to, make that argument in court, right? But it's either for one of two options from my perspective, and it's number one, because this is the argument that I need to make to win this case, right? I'm arguing on behalf of my client.
Right.
And the other one is just to essentially prevent somebody from taking on another client and saying, no, you know, Mr. Smith, that client that you went out and retained and paid money to probably market for and you know, pay money to run a business and support their case. You're not allowed to accept their money. You're not allowed to take their case, and you're not allowed to argue on their behalf. And it just seems really personal.
Does it help or hurt the fact that I've never lost to this firm before? Does that give you some other insight? It actually is true.
Well,
yes.
then.
So there's that. We've had a couple of other trials. We've had so many trials over the past couple of weeks.
We have
just trial after trial after trial, and we had another recent trial that was fascinating to me. And maybe we can whip through it. I don't know if we can do it justice whipping through it, but
I don't know. I think we got a shot.
Yeah? Okay. So we've got mom and dad, and we've had this client forever.
Yeah.
They've been
years
litigating. Well, the divorce was 13 years ago, and we weren't on the case initially, but these parties have been in court with new motions and new allegations every year over the past 13 years.
Right.
Now, when a judge sees that, what do you think the first thing in their mind is?
Oh, geez.
Oh,
here we go again.
Here we go again, because it's usually the same judge that gets to hear it. And in this case, since the time I've been on it, it's actually been 4 different judges.
Oh, wow.
It's kind of bounced from judge to judge because for whatever reason, there's been a judicial reshuffle, and the judge with the case is always like, oh, I'll just randomly give this one to the new judge. Oops, oh, too bad for me. You know, it ended up with the new guy. So we get new case after a new judge after a new judge on this case, and every time we get a new judge, mom decides to refile, right?
Yeah.
Oh, you know what I need? And these parties have had joint custody for years, right? And every time there's a little glitch, mom is back in court. You know what? I need primary custody this time. I need to wrestle the primary custody from dad. And they were fighting, obviously, before the kid was born. They divorced when the kid was 2. And the kid is now about 16 years old. And every judge over the past 13 years has told these guys, you know what, you guys, you're ruining your kid. You're going to start to have some problems down the line that you don't necessarily have now. But mark my words, if you keep this up, if you keep forcing this child to try and choose between you, you're going to pay the consequences at some point. And guess what happened?
It's time to pay the piper.
It's time to pay the piper. And, about 4 years ago, mom filed a motion. She decided she couldn't win. So she decided to try and push the issue to force the judge to make a decision. And so she files to move to another state. Let's call it Oregon. And the judge is like, no. I'm not going to let you move. And she's like, oh, darn it. And so then about a year later, she files again. She says, listen, now I don't want to, Oregon, that was the worst idea in the world. I'd instead like to file and move to New Mexico. And the judge is like, yeah, no, I'm not going to let you move. And so she just moves, right? Mm-hmm. She moves and she leaves the kid with dad. And what she was fighting for all these years to get primary custody, she essentially concedes to dad. Yeah. And now dad's got primary custody of this kid. Yet another stellar victory for Smith Legal Group. And so for the past 3-ish years, dad's had primary custody. Well, there's been a whole slew of things go on over the years, including allegations from the child that stepdad has been inappropriate with her, that stepdad likes to try and hug her when she's naked, that stepdad has given her tongue kisses in the past. My gosh. You know, it's a horrible, horrible case. And as a result, guess what's going on with the kid?
She's having some mental problems.
She's having some problems, yeah. Right? And as a result, she's been put through the ringer psychologically. She's been put through the ringer through counselors and the whole 9 yards. And still mom, who's still with stepdad, by the way, is fighting for primary custody yet again, and we ended up going to trial on that very recently, and it was you were there, right?
Yeah.
It was comical because Mom has this attorney who's a good attorney, right? But the attorney, and she's got these two huge notebooks full of evidence, right? And she did, during the course of the trial, she would advise, let's turn to Exhibit 1. Read for me sentence 1 here on this page that I've got highlighted. And on there, it's like, Dad is a horrible person because blah, blah, blah. Like these are medical records, right? And the doctor's like, the child says that Dad is a horrible person. And then the next 3 sentences below are, but Mom's even worse because here's what she's done, and the child's really upset with stepdad and blah, blah, blah. Every single time, right? And so we're going through all this, and as we're reading this, I'm reading going, okay, you would really show the judge this page with this 1 good sentence and these 3 bad sentences against your client? And so as soon as the opposing counsel's done, I get to go back through and point out, let's turn back to the page you just read. Now, read me the next sentence. And she starts going through and reading about what a horrible person she is. And then I'd ask her the questions, right? Do you think there's any medical records that point to the fact that maybe the child blames you for moving? No, there's nothing like that. Well, why don't we turn to page 8075? What does that say right there? Well, the child's upset with Mom for moving. Oh, okay. Well, I thought you said that didn't happen. Well, it did. She's just lying about that. That's the lie part. The truth is the part that I showed you over here.
Right.
And we go through this whole trial, and I start asking Mom why she eventually moved, because there's this abandonment issue that probably took place. The kid's wondering why Mom left the state without her, if there's this strong bonded relationship that you're saying. And it turns out that stepdad has always had the same job. He's making the same money here and he's making the same money there. The only reason to move was to get away from Dad. And as I'm pressing this issue with Mom, opposing counsel lodges an objection. Objection here. What does this have? What does stepdad's income have to do with anything? And do you remember the judge's reaction?
Overruled was the...
Well, it was overruled. But then the judge looks and she's like, quite frankly, Mr. Smith doesn't need to keep beating this horse, okay? We all know what's going on here, and I'm going to tell you right now, Mom, you've been in here every year for the past 13 years, and if you think you didn't have any part in this, I've got some news for you, okay? You're at fault. You did this, right? And not just you, but you're at least 50% to blame. And that you can come in here and say with a straight face, I think it's 100% Dad's fault. You're nuts.
Yeah.
Why would you do that? Why would you expect me to believe that? You guys have done this together. And not only is Mr. Smith correct that there's some culpability here, every judge that you've ever been in front of has forewarned you that you would get to this point. Why? Because there's some kind of Nostradamus? Because there's some kind of sage? No, because we handle thousands of cases a year, and in every single case where there's a mom and a dad at each other's throats for a decade and a half, guess what? Their kids are screwed up. And guess what? We told you about it, and guess what? You didn't do anything about it, and look where we are. So you want to start pointing the finger? You better grab a mirror, because the finger points right back at you, and Mom's sitting there. And then the attorney's on the other line. Rooney!
Rooney! Get in here!
Sorry for the Ferris Bueller reference, but
I appreciated it. Don't apologize to me.
And so the judge says, look, I'm going to give you a chance here, okay? Rather than finish this all-day trial, which I've spent 6 hours too long on, why don't you, counsel, take your client outside and see if we can't get this thing resolved? Because if you force me into making a decision today, I promise you you will not like what happens here. You are going to have some very adverse decisions against you, including probably giving dad sole legal and sole physical custody, because your interference with the child's medical care at this point is astronomically preposterous. And attorney looks at the client, and the client's like, she's like, just a moment, Judge. We got to do this. We got to do this right now. And so the client's like, yeah, Your Honor, can we have 5 minutes out in the hall? Maybe I can talk to my client a little bit more in private. And the judge is like, sure. Why don't you take your client outside and see what we can do? And she pulls the client outside. Now, listen, I couldn't hear what was going on. But what I did hear was pots and pans banging and cupboards slamming and dishes crashing to the floor and muffled voices and what sounded like fisticuffs going on back and forth between the attorney and the opposing party. And when they finally came in, hair disheveled, all something about married up with the hair going, and the attorney's like, Your Honor, my client would like to withdraw the motion. And the judge is like, Madam Client, is that true? Would you like to withdraw your motion? And the mom's sitting there. Yes, I would. It was one of the more comical things that I've seen in what really was a horrible case, but I think that was probably the right decision on mom's part, because she's about to get destroyed. But the moral of the story is this: when you're going into court and you're going to use this documentary evidence, you better make sure that it points to just the other side, not have in the exact same sentence the records pointing to your client as well. And in fact, the judge is like, I don't know if you guys have seen the CPS records, but oh my gosh. And we're like, oh, I didn't see the CPS records. What do they say? There's 130 pages of CPS records, and they all point to the fact that these are, that there's been problems over the years. And if you think I'm going to take a child who's having obvious issues right now, her statements, on one page she says it's one parent's fault, on the other page she says it's the other parent's fault, and guess what? I don't believe her as far as I can throw her.
And with her bad knee, she really shouldn't be throwing anybody.
Right. And so I guess that's the moral of the story. So look, if you like the stories that you've heard today, all of which are true, no embellishment whatsoever, like, share, subscribe, and help us keep these stories coming, because we've got 1 million of them, and I've got 1 million more for next week, and wow. But we will see you next time on The Legal Smith Unleashed.